Hello everyone and welcome to today's session. Are you prepared? Understanding the sanitary transportation of human and animal food rules and the potential risks. I'm Hal Pollard, the Director of Education at IANA. Today we are going to dig into the rule and talk a little bit more about what it means for intermodal. I am pleased to welcome to our panel Ted Prince, the Chief Operating Officer of Tiger Cool Express, who will be moderating for us. Stephanie Penninger, the Senior Litigator for Benesch, Friedlander, Copeland, and Arnoff. And Chris Lilac, an attorney at Benesch, Friedlander, Copeland, and Arnoff. Today we're going to step through the FSMA and what the sanitary transportation rules really are, kind of look at who's covered by the requirements, tackle a few examples that are real world for intermodal, and then do some practical advice sharing, and then jump into Q&A. So at this time, I would like to hand it over to Ted Prince from Tiger Cool Express to give us the lay of the land.
Okay, well, thank you, Hal, and good afternoon and good morning, depending where you are. I'm glad you could take time to participate in one of these IANA webinars. The Food Safety Modernization Act, or FSMA, was enacted, legislated 2011. It really becomes fully effective next Thursday and can really be a game changer for intermodal. Like many past regulatory initiatives, the intermodal industry is entering a period of enhanced compliance with a certain amount of trepidation and a certain amount of uncertainty. Because as clear as the legislation is into the four categories of transaction partners, which our presenters will talk about in a minute, when intermodal, it's always very confusing because in many cases there are buyers and sellers and intermediaries of transportation services, and that makes it much more complicated. Given the fact that legislation mandates enforcement by the Food and Drug Administration, with which this industry does not have a great deal of experience, and the fact that penalties include up to criminal exposure for officers and boards of directors, certainly the price of poker has gone up. As Hal indicated, we're going to approach this webinar in three parts. We're going to have the overview of FSMA. Second part, and we had some advanced preparation and we asked our panelists to see if they could address specific issues of unique interest to the intermodal industry. And finally, we'll be open for question and answer. So with that, we're off in the Wienermobile.
Thanks, Ted. This is Chris Lilac talking at this point, and thank you for the kind introduction. Myself and Stephanie will go back and forth here throughout the next few phases here of the presentation. The first one here, though, before we begin addressing some of the more practical, in-the-weeds type questions, we do owe you a bit of background as to what exactly the new rule is. We are going to make a conscious effort to not spend, know that sometimes a FSMA presentation could sometimes have the tendency to get bogged down in talking about the regulations and maybe a little bit light on the practical impact. And we're going to specifically try to avoid that here, but we do have to talk about it just a little bit before we delve in. One thing to note here is that as we are going through this, since we are covering it a little bit faster, if there's anything about the regulatory framework or if there's anything about just the rule or how the rule works, please do not hesitate to bring those questions to our attention. We may take them at the end, take those questions, and make sure that any sort of misunderstanding that's related to that is covered. So that said here, ground zero for the FSMA is the underlying legislation where this all comes from is the Food, Drug, and Cosmetic Act, which is not a new piece of legislation at all. Went into effect in 1938. What you see in that piece of legislation is the term adulterated, which is a common term that you see, and maybe you're already seeing that in certain agreements that address FSMA that may already be coming to you. You see that word adulterated. It's a common buzzword. Well, that word comes from the Food, Drug, and Cosmetic Act because it's that legislation that prevents the transportation, distribution, I should say, of adulterated product, whether that product has been under insanitary conditions or may have been rendered injurious to your health. So that's where adulterated comes from. Now, the law itself here, the FSMA itself, which, as Ted had mentioned moments ago, was signed into legislation in 2011. And here we are, 6 years later, actually finally getting the first impact of these rules. So I see that, I've had this experience when talking to certain clients who are, covered entities under the regulation. They say, look, Chris, I've been hearing about FSMA for a long time. I've heard about it since 2011 and maybe even before that. when it was in its planning stages, and now we're only now getting to the point where we're actually having to deal with this. So why should I be that concerned? If nobody else has any sense of urgency in getting this legislation out there, why should I be concerned about it? Well, the truth is that the criticism of the FDA getting the rules out here is extremely fair. It's taken them a long time. Matter of fact, they were sued into having to do it in the first place. So, I cannot fault anyone for being a little skeptical as to how aggressive the FDA is going to be in enforcing it, especially under the new administration. Just remains to be seen. But what I can say is that now that we have covered entities where there is actually a liability impact as a result of it, there's a good chance that the court system will work this out, because claims will happen, there will be issues with product, and FSMA is going to be a new thing that you're going to want to be compliant with to show that you did your job if you find yourself in one of those claims. So that said, I'll turn it over to Stephanie.
So I'm going to go through just some of the general requirements of the FDA's Sanitary Transportation of Human and Animal Food Final Rule. And I may refer to these new regulations that are the ones that we have to comply with, most of us, on April 6th of this year. Some of the smaller entities that are covered have 2 years to comply, so they've from the publication date, so they have until April 6, 2018. But I may refer to it as the STF rule in my commentary, but those are the regulations I'm talking about that tie into the food, drug, and cosmetic that Chris just mentioned. So the focus of these regulations are predominantly on requiring certain equipment and designs of equipment to be provided when transporting food, and there's got to be specific washout and cleaning procedures in place, which in most cases they already are there. A lot of what these regulations do is require a lot of the best industry practices that are already going on in our industry to be memorialized in writing, and there's more accountability there because of the contractual requirements. So there's some self-policing in addition to the FDA being able to fine and criminally penalize those that aren't complying. Other focus areas of the regulations are on trainings. Motor carriers have to provide training to their personnel who are going to be handling the transportation of food, and there's also record-keeping requirements. Pretty much most of the records that are involved are going to have to be kept for at least 12 months, and we're talking about the written instructions and procedures and the contracts that are required by these regulations. Even though only motor carriers are obligated to provide training, it's important that others who are covered by these regulations, the shippers or the brokers who are defined within the scope of shipper, the rail and motor carriers, the receivers, the loaders, all of those players need to make sure that those who are going to be handling food know what they're supposed to do under the regulations, what the risks are involved in transporting food, and ways to address any identified gap areas. The regulations also have there's some general requirements that covered entities have to comply with, and then we're going to talk a little bit later about some of the requirements that motor carriers have to the extent that they are obligated to do so in writing. In most cases, it's going to be by contract, whether it be the bill of lading as the contract or an actual written, signed, more comprehensive agreement. So the general requirements that apply are focused on avoiding cross-contamination and cross-contact between foods and non-food items, raw and ready-to-eat foods, and items of food that would be considered food allergens. There's also regulations that are in the new STF rule that focus on temperature controls and maintaining temperature during transport. Although there aren't details given as to how this has to be done, they require, to the extent that the shipper deems the food necessary to be temperature managed during transportation, then the specifics have to be in a contract, and the carrier would then agree to provide information regarding maintaining the temperature during transport as required by the shipper's instructions. And then the regulations also indicate that if anyone in the food supply chain that's covered becomes aware of a material failure of temperature control or anything else that might render the food unsafe during transportation, then that entity that becomes aware has to make sure that the goods are held and are not released further into the supply chain without having a qualified individual do an inspection. And while that qualified individual is not defined and there's no certification program like the goods manufacturing practices, what we would advise you to do is in your contracts and your shipping documents, make sure to identify who's going to be the one to make that determination. You don't want to be left using the shipper's quality assurance personnel to make that determination without having an opportunity to get a USD inspection or somebody more removed from the transaction to make that determination. Now, Chris is going to highlight a couple things to be aware of in the regulations.
Absolutely. So one of the things that you should be aware of here is take a look at this language here that's on the screen. Basically just says, and I just want to draw your attention to the deliberate vagueness here that the FDA used. So you can see that the highlight of the rule is that vehicles and transportation equipment must be designed and maintained and stored to prevent food from becoming unsafe. And they must be adequately cleanable for intended use and capable of maintaining necessary temperatures for safe food transport. Well, that's pretty vague, right? That really doesn't tell you much of anything. So the reason I'm drawing your attention to that is if you were following the initial rule as this thing was coming out, the original rule, before this final rule went into effect, was a lot more heavy-handed. It was very prescriptive. The FDA arguably required everybody to have continual temperature monitoring. That is not part of it here. They arguably were going to require that temperature monitoring be extremely strict. Things were going to be pretty strict under the rule in its initial form. Now, the FDA got scores of comment letters complaining about that, saying that's ridiculous, you can't be so heavy-handed with it. And the FDA, to their credit, listened to the advice that was received, and they ended up saying, you know what, you're right, we are not the experts on food, you guys are. So we're just going to say that you have to meet these requirements. We're going to be very vague as to how these requirements are met. We're going to provide some very vague requirements, and it's up to you as to how you define those requirements. So wanted to bring your attention to that because there is a possibility that you may see a contract come across your desk or come to you that was written with the misunderstanding that the FDA was going to require things that it simply isn't requiring. And that'll come in later because one of the things you want to keep in mind is that you're not agreeing to things you don't have to agree to. There's obviously no benefit to you in doing that. So in the transportation operations, you do have to develop these adequate temperature controls, contamination controls, so on and so forth, but how you specifically meet those goals is largely been left up to those in the industry. Now, with all of that said, I bring that to your attention because now we're getting to this page here. This slide here, maybe the most important slide, at least as far as I'm concerned, is that the rule specifically allows allocation of responsibilities by agreement. So what does that mean? Everybody under the new rule, you're going to fall into one of a few categories if you're covered, okay, in the transportation operation. You can either A, be a shipper, which if you happen to be a shipper, or if you happen to be a broker, brokers are also considered to be shippers under the new rule. That was an area that was ambiguous before and is now cleaned up. If you are a broker, even if you never touch the load, you are responsible for food safety as well as a covered entity. So shippers, which includes brokers, carriers, which obviously is somebody who's a carrier of the freight, a loader, who is somebody who loads the freight onto the trailer, and the receiver, who is somebody who receives the freight, unloads it from the trailer there at its destination. Now that said, especially in the intermodal context, you may be thinking, wait a minute, maybe I'm more than just one of these. So which one am I? Well, the answer is you're both. You can certainly wear more than one hat under this new regulation. You can be a carrier and a loader. You could be a shipper and a carrier. You could be more than two as well. So something to keep in mind is that you may be more than one person under these. Now, within those entities, the FDA has allowed those entities to assign certain responsibilities to each other when it's appropriate. So a good example of that would be if you're a broker. You definitely don't want to be responsible for a lot if you're a broker and you're never even handling the food. You want to make sure that your agreements are addressing that. So that's just one example. So with that said, the understanding that responsibilities can be allocated, I'm going to turn it over to Stephanie, who's going to talk a little bit about what responsibilities, so what are the default responsibilities for those different components that we talked about.
For sake of time, I'm going to speed through some of these slides on the responsibilities, but just to give you an overview of what each covered entity would be required to do. The shipper and broker responsibilities are threefold. They have to provide instructions, and I'm looping the broker in with the shipper because we mentioned before they're considered a shipper under the final rule. They have to indicate the specifications for transporting the food, for example, the equipment, the design of the equipment. And then they have to tell the carrier, to the extent that the food requires temperature control, they have to specify the operating temperature and any pre-cooling requirements. Then there's also a requirement that there be a written procedure in place that would ensure that the vehicles that are going to be transporting the food meet the requirements and that the food is transported safely. And this written procedure is something that would be followed internally. It doesn't have to be given to anyone, but you would have it in place as a shipper or broker to the extent that the FDA came knocking and asked, if you were, how your operations were being run, so that you were ensuring that the carriers that are transporting the food are doing what they need to do to be able to make sure the food is transported safely. So that's something that needs to be in place, even though you're having the carrier, you're pushing a lot of this, as Chris mentioned, through agreement to the carriers. You still want to at least have everyone on page as to what needs to be transferred to the carrier, and then what the broker is still going to be responsible for, which would be predominantly being the messenger, transferring the instructions from the actual shipper to the carriers and anybody that might be loading that's not the shipper. And then the third requirement is the record-keeping requirement, which I had mentioned before. The loader has the responsibility to inspect the trailer and other equipment being provided to make sure that it meets the specifications given by the shipper. They also are responsible for making sure that there's the equipment sufficient for maintaining temperature control to the extent the food needs to be maintained at a certain temperature or within a certain range. Also need to do a visual inspection and make sure that there's no physical evidence of conditions that would cause or lead to adulteration of the product during transportation. Making sure there's no leaks or infestation or anything that would be visibly obvious that could cause a problem to the food during transportation. And if the loader doesn't do all of these things, then their failure to do so would likely be considered the act of the shipper, such that it could provide the motor carrier with a defense in the event that there's a cargo claim later down the road. The receiver responsibilities are to assess that the food was not subject to significant temperature abuse, and they do that by determining the temperature of the food at destination, the vehicle's temperature setting. They determine the ambient temperature of the vehicle, and then they too do a sensory inspection to make sure that there's no visible evidence of anything that could have potentially caused adulteration to the food shipment. Then the carrier responsibilities, I had talked earlier about some of the general responsibilities that everyone is required to abide by, but the carrier also would have some additional responsibilities in the event that it agrees to take on these responsibilities in writing. And we would normally see this and are helping many of our clients and developing, depending on what side our client's on, these written contracts or, adding provisions to existing shipper-carrier contracts. And in those agreements, the carrier, to the extent that they agree to do so, would be responsible for making sure that the equipment and the vehicles meet the shipper's specifications. They would agree to provide the operating temperature and any evidence, and to provide evidence that the requisite temperature was maintained during transportation upon request. They would also, the carriers would pre-cool the refrigeration storage compartments and be able to, upon request, demonstrate that prior cargoes, when we're dealing with bulk vehicles, they would be able to demonstrate what the prior cargoes were and their recent cleanings to help ensure that those prior cargoes wouldn't cause the current food being transported to become adulterated. And then the carrier also has to have a written procedure in place specifying how they're going to make sure the equipment and vehicles will maintain the integrity of the food during transportation, and specific washout and other types of procedures, which would normally be found in the SOPs. A little bit about enforcement. There's not a lot of detail out there how enforcement is going to happen. There's no, like in other regulations, there's you would see a complaint mechanism, a hearing mechanism. There's nothing like that in these new regulations. Instead, there is indication that the Department of Transportation is going to make inspecting trailers for compliance with the new STF regulations a part of their routine inspections that they conduct already. So in the event that there was some visible evidence of violation, that could be a part of the inspection process and result in sanctions for violating the regulations. There's also indication that the U.S. Department of Justice can seize food, and this actually comes from the Food, Drug, and Cosmetic Act. So the U.S. Department of Justice has always been allowed to seize food that if it determines that the food would be adulterated. There's some penalty provisions that are part of the Food, Drug, and Cosmetic Act that the FDA has authority to enforce, and those are civil fines, and they're able to criminally prosecute individuals and companies that violate the food safety regulations. So now Chris is going to lead off with addressing some of the more industry-specific to multimodal transportation situations.
Thank you, Stephanie. So yeah, now we're, with all that said, talking about the framework, going to roll a little bit into the practical side of this. As we get into these questions, I think it's good to note that there's a few things that you should always be asking yourself as you're entering into agreements or you're figuring out, how to address FSMA issues that come to you or food transportation issues that come to you. Number one, we talked about the different roles that we're in or that you could be in. Number one is identify which role you are in. It's worth noting that we touched a little bit about how a broker is a shipper. A shipper is very broadly defined under the rule as somebody who initiates a load. So are you a shipper? It's quite possible as well. If you're not the shipper, who is the shipper and where are you getting your instructions from? Because as Stephanie had covered in her portion, the shipper is the person, because remember the FDA took this very hands-off approach to making the new rule and said we're not going to define what the responsibilities are. Well, somebody is, and that person is going to be the shipper because we're going to assume that the shipper is in the best place to do that. So the rules could almost very simply be boiled down to the idea that the shipper sets the instructions and everybody else has to comply with it and make sure that the next chain is complying with it as well, or that information is, that information is being passed on. So one practical application question number one, that's why we put that here, how should the shipper provide information to you? Now that's a common question. That the answer to it, I'm going to give a very lawyerly answer here, is going to be it depends, okay? And what does it depend upon? It depends on a few things, but the first one is going to be what is most convenient for you and your operation, number one. So you should ask yourself today, how are you getting your shipper information from the shipper? If the shipper is telling you that you are hauling a load of yogurt and that yogurt is supposed to be hauled at 38 degrees, where are you getting that information? Is it just on the bill of lading? Okay. Is that convenient to you? Okay. Well, what happens when that information is not listed on the bill of lading? Well, what you want to do here is take a step back and make sure that your agreements reflect where that information is going to be coming from and how it's going to be provided. And you also want to ask yourself how you want to address it when that information is not there as provided. Because ultimately, you don't want to be stuck in a position of looking like you didn't do your job or entering into agreement where you agreed to something unrealistic. So ask yourself the question, how the shipper should provide the information to you and what's most convenient to you, and make sure your agreements reflect that.
For those of us in the intermodal world, I think one of the areas of confusion is that if you are a broker, it's actually the consignor, let's say, it's actually right. Shipper to shipper. Misinterpretation by the broker's customer that they're looking for the broker to act really as a carrier when it's really a shipper to shipper transaction. And I think that's the source of a lot of confusion.
Ted, you're spot on there with that, and thank you for that comment, is that you are in fact dealing with, regardless of whether or not you have an agreement, that where the shipper, if you're a broker, and the shipper is calling you a carrier, or calling you whatever, or treating you as a carrier, doesn't change the fact that you still are a shipper. And as a shipper, you incur some default responsibility for making sure that the information regarding temperature control, making sure the information regarding sanitary equipment is all passed on effectively down to the actual carrier. So how do you do that? And Stephanie is going to address that in one of her questions as well. but let's touch on it here because we're here too, because it certainly doesn't hurt to address this early and often, okay? You want to make sure when you are in, I would say the broker more than anybody else, everybody here has new risk, but I would say the broker who isn't even touching the product, I feel like incurs more new risk than anyone else, and is in more of an area to get kind of exploited for being on the wrong end if there's some contracts that the language hasn't been looked at in a long time. So what you want to do, getting down to it, you want to make sure that you are clear as the broker how that information is going to be passed to the carrier. Now, if it is a consignor who has just a bill of lading and they say, well, it's going to be on the bill of lading, then that's going to make its way to the carrier. Well, you want to make sure that your agreement as a broker with the shipper very clearly specifies that the shipper is responsible for putting that information there and conveying that to the carrier effectively, and that you are not responsible for the shipper's failure to provide that information.
And I might just add that it would be good to indicate in the contracts that you have, whether it be a rate confirmation or whether it's an actual signed contract that's comprehensive, but have the shipper indicate if the shipment is a covered shipment, because they're in the best position to know that, on the shipping documents themselves. For example, the bill of lading would be a place to put that, as well as temperature ranges and specific instructions. But you want to streamline the process. You want to avoid the shipper being able to give instructions in many different ways that, you know, they might claim they provided, but you weren't looking or expecting it to be in a particular document. You want to really streamline the process, and you want to avoid, you know, in your agreement, to the extent you have a formal agreement, to have it as part of that agreement so that you have a very defined, limited ways in which those instructions can be provided, so that, and you don't want to be cross-referencing lots of different documents. But to the
So what I was going to ask is, when you think about fresh produce, which is probably the majority of the intermodal cargo that falls under this, a great deal of that business exists without a contract and basically falls under, you know, PACA and Blue Book guidelines. So there is no formal contract, and the bill of lading is really not known until the drayman picks it up in the intermodal transaction. So how do you protect yourself in that type of environment?
Well, you're going to have more incidences of written contracts now. You're not going to be able to get by on just on Blue Book guidelines, which aren't binding law. You're going to have things be in writing, and what we're suggesting is maybe an option would be to have your rate confirmation, to the extent you're a broker, have your rate confirmation incorporate online terms and conditions or other terms and conditions that you have control over. So to the extent that there's not a document stating otherwise, your document comes into play as to how the instructions have to be governed, how you want the shipper to do all of these things, so that you're dictating it. And to the extent you're a motor carrier, you can include some of these provisions that are more motor carrier friendly in your terms and conditions and rules publication. So that way you'll have something that would kick in and come into play on a document that's part of the transaction. But you're going to have some way of showing that the shipper had noticed or aware of these requirements, but here you're going to have something locking them down in writing. And to the extent you don't have a formal contract, you want to do it by way of your rate confirmation and terms and conditions.
Good point. Thank you.
Yeah, absolutely. Just to put I guess a fine point on that, maybe hopefully not too fine of one, but Stephanie had indicated using the rate confirmations and the terms and conditions, if you're a carrier, that is a great way to make yourself money on this, because we know that you don't have time. You're busy. You're trying to actually move product here, right? You don't have time to negotiate every term, and frankly, you might be dealing with a bigger entity that isn't going to agree to certain terms. Well, guess what, though? If you can negotiate a term instead of negotiating every little thing into the contract, if you can negotiate just a simple term that just says, to the extent that this agreement is silent, carrier's terms and conditions shall apply, or broker's terms on the rate confirmation shall apply. If you can get that negotiated in to the agreement, they're not going to read that, and nobody's going to look at it until the proverbial feathers hit the fan and there's a claim down the road. And you could put all kinds of self-serving provisions in there in your confirmations or your terms and conditions, and those will be enforced. So,
And those confirmations work both from the carrier to the shipper or the broker shipper to the shipper.
Yes.
It works both ways. And just real quick before we go on, Stephanie, for those not familiar with it, could you just expand on the Blue Book not being published law?
Sure. Since the Blue Book, they're merely guidelines. They're not laws. They're not, enforced by any kind of governmental agency or legal body. And they're definitely, helpful and they're good to have, but they're not binding law. So the FDA, these new regulations are binding law, and those are the ones that are going to be enforced by the FDA and other governmental entities that are able to punish those who aren't complying with them. So you want to be mindful that, the two can work together to some degree, but just because you're following Blue Book guidelines doesn't mean you're automatically complying with these new laws, which do actually specifically mandate certain requirements that the motor carriers are going to be, in this segment of the world, are going to be the drayage companies, and the IMCs are going to be the brokers, and you're going to have certain requirements in writing and agreed upon by the drayage companies in order for them to kick in. Otherwise, they're going to remain with the companies that fall within the definition of shipper, which would include the brokers and IMCs.
Okay.
Good stuff.
Thank you.
Chris, if you want to maybe address the employment status question with your employment law background.
Thanks, Stephanie. So this next one here, how does training impact employment status for carriers? This is a very sophisticated question, and it warms my heart as a labor and employment attorney to see it get asked. And so what does this even refer to? Well, there's the concept out there, if you're familiar with it, called the notion of whether or not somebody is a joint employer. And what that means is if you have control over somebody else, just very simple, if you have control over another entity, then you can be considered, especially under recent National Labor Relations Board law, you could be considered to be an employer of that person too. So the question comes up, well, if I'm, in drayage, I'm a drayman, and I'm using owner-operators as my drivers, well, wait a minute, it says here that I have to have training. And now, does that make me a joint employer because I am giving these guys training now? And it's a very good question. And the answer to it is, well, we hope not, but the way that you can insulate yourself from that is if you are in that situation where you're dealing with independent contractors as your drivers, make sure that your training plan provides very clearly that this is not something that is done with the effect of creating an employment relationship. It's being done to meet the regulatory guidance under the Food Safety Modernization Act. And make sure that your documentation makes that clear, and that there will be helpful evidence against any such finding. But good thing to keep in mind, just make sure that your documentation states that it is something that you are doing for the purpose of meeting a requirement and is not done for the purpose of exercising control. I'll toss it back to Stephanie for this question about carrier exemption.
Thanks, Chris. So a question that comes up oftentimes when we're addressing food safety issues with our clients is, and it particularly comes up with our broker clients who ask us whether if they are transacting with a carrier that's exempt under the regulations, like for example, maybe they fall within the small carrier exemption, or they're one of the smaller businesses that are covered, but they don't have to comply for another year. They've got the 2 years in the two-tier compliance state as opposed to having to comply by next Thursday. Well, in that case, there's a question as to whether the whole transaction's exempt. And the short answer is no, that you as a broker who is defined as a shipper, you're going to be on the hook to the extent you can't assign through written agreement some of these obligations to the carrier. And if the carrier isn't going to be able to undertake those obligations, they're either not going to sign the agreements and take them on, or they will take them on blindly and not be able to comply with them. And then push comes to shove, the broker is going to end up left holding the bag when the shipper can't meet those requirements. They're going to be on the hook, typically contractually, to the actual shipper that they're their customer by agreement, and could potentially be in breach. Or the FDA could come in and say, you're responsible for making sure that the food product is transported in a sanitary condition, and you are transacting with those that can't ensure that, so you're responsible.
So just to clarify, Stephanie, if Acme Produce tenders to broker A, and broker A contracts with small exempt carrier C, small carrier C does not have any responsibility to the broker because of the exemption, but the broker who still has that responsibility to Acme Produce.
Correct.
And they're stuck in the middle. Okay. I just wanted to clarify that. Thank you. I don't think that's widely understood.
No, it's not. I have that question come up all the time. And I think that's part of what the FDA is doing, is trying to weed out some of the companies that aren't going to be able to comply with the standards, and, you know, sort of effectively the companies are going to be self-policing through these agreements, and if they can't meet the requirements, then the brokers are not going to be able to hire these carriers.
So just to drill into that one other piece, if the broker has a responsibility to maintain a history of the temperature of the box while it was in transit, that means they've got to retain that data whether or not the carrier even sent it to them, or if they get it from the carrier, they have to retain it as well. So in other words, Acme Produce requires that the broker, who they're viewing as this quasi-carrier, has a history of what the temperature was inside the load to see if it exceeded the temperature setting for a predetermined period of time.
Right.
So I guess, A, does the broker need to retain that history? And if so, do they have to then obtain it from the carrier and archive it themselves?
So the problem here is that a broker should not be agreeing to maintain temperature in their contracts with the shipper. They should be, I guess, if anything, they would be agreeing to require their carrier to maintain the temperature. And then the carrier would have to you would have to specify to the carrier exactly how they're supposed to keep this history and data, because the rules do not specify exactly how the data is supposed to be recorded and maintained. But to the extent that the carrier agrees to provide this information upon request, you'll have to pass along. However, Acme Produce wants this to be recorded and provided to the extent, you know, a question comes up. You know, that's got to be passed on specifically to the carrier, ideally through a written agreement. But yeah, the broker should never be obligating itself to record something when it's not operating equipment, and it shouldn't agree, if it can, to ensure that a carrier will do what it's supposed to do, but it should say that it will require the carrier to maintain the data, and typically it's through a time tail, or even better would be through telematics, so that there would be clear history of the temperature that could be retrieved electronically easily.
To add on to that, though, so part of the question was also, do they have to retain that? So it's worth clarifying here also that it is the carrier's responsibility to provide the temperature information, that whether that be through a download or telematics, whatever, to the shipper upon request. The shipper doesn't necessarily need to request it, but the carrier has to be prepared to provide that information in a way that's specified by the shipper. Now that said, once the shipper has requested that information, or if you're as a broker have been requested to request that information from the carrier, depending on how that all works out for your agreement, regardless of how many times that is, then I would say yes, that becomes part of your record-keeping obligation now too. Now that you've requested it and have it, you should be holding on to it as well for the 12-month period.
So if one of the questions that comes up a lot is if the consignor shipper tells the broker to see bill of lading, or BL, who's responsible for reviewing the bill of lading?
Before you go in, this was asked specifically in the context of Intermodal, where the drayman is picking it up.
Well, and Chris may have something to add here, but what I would say is that the instructions on the bill of lading are really designed to be for the drayman and the drayman's drivers to be able to, for example, maintain temperature control if there's a temperature control requirement, things of that nature. And it really needs to be only the broker's responsibility to pass along any instructions to the carrier, not to abide by or follow any instructions on the bill of lading. So unless there's some kind of contractual requirement, I would say that this is pretty ambiguous to be able to bind the shipper to comply with the bill of lading and what's on the bill of lading. But of course, what's better is to be able to clarify this in writing between the different parties and make it clear that the broker is acting as a messenger of information and will be providing this instruction to the drayman picking it up, and that it's the drayman's responsibility to abide by what's on the bill of lading and those instructions that are there.
So let's just drill into this a little bit more, because usually what happens is the tender, the original communication from the consignor shipper to the broker shipper usually says, 38 degrees or BL governs. So part of the requirement, right, under FSMA and most industry practices is that the box needs to arrive pre-cooled at the origin. So you're going to have that. The problem that we see is that frequently there are multiple bills of lading, and sometimes it's even hard, especially when ERP systems are consolidating shipments literally until the time they back up to the door. It's kind of difficult for us, let alone the drayman, to understand what exactly are the bills of lading, and for them to actually go through these multiple purchase orders / bills of lading that may have varying or conflicting temperatures. So I guess the issue is the practical of what's happening at the dock and the legal requirements, given that requirement from the consignor shipper to the broker shipper to the drayman, if that makes sense.
No, it does, but it's a very practical question. If you've got competing bills of lading that have varying temperature requirements, then we have a problem, and we're going to have to figure out a way to address it here. As a practical matter, I would say a good spot, and this is something that I defer to you on, or anyone in industry really on this, is what do you do right now when you currently have multiple competing bills of lading that say different things? This says the yogurt's supposed to go at 36, this says 38. How do you do that?
I plead the fifth.
Okay. And I would imagine there's probably different workarounds here, and I suspect maybe one way to do it is that people are saying, well, I'll just put it 38 and go on, and we're not going to worry about it. Well, okay. You do want to make sure, though, that you're covering your bases here. Maybe you say, if you could pick a certain bill of lading, you say, look, in the event that the bills of lading are conflicting, then this one shall apply. The one that's generated by this entity shall apply. That's one way to do it.
Or the first one.
Or the first one. Now, getting back to the actual question, though, we're talking about in the context of a broker. What I would say, if I'm the broker who never even touches this, and there's going to be maybe multiple bills of lading flying around, I'm going to say, look, my agreement with Mr. Shipper, the shipper, is going to say that it is broker's understanding that since it is the party's understanding that since broker will not be in a position to handle the freight, the shipper is responsible for providing that temperature information on the bills of lading in a clear and unambiguous fashion. And shipper and the parties agree that shipper and only shipper shall be responsible for any loss caused due to ambiguity in conflicting information. And I would say that, and if you can't get that negotiated in, I think that's a good thing to try and get into your terms and conditions.
Okay, thank you.
The next slide is non-rejection of equipment for loading and play, acceptance that the equipment is clean and sanitary. So I would say that if the food is loaded onto the equipment and nothing is written on the bill of lading or otherwise indicating that the equipment was not acceptable, and there's no evidence that anyone on the dock made any kind of complaint, then I would say that it would be a good defense in the event that later down the road there was a cargo claim because the food was determined to be adulterated. If they claim it's because of equipment malfunction or a trailer issue, I think it would provide a decent defense to the drayage carrier that the goods were loaded on the trailer and that the equipment must have been in conformity with the shipper's instructions. I would go a step further, and I would indicate that in the terms and conditions that or an agreement, if there is an agreement, that if the goods are loaded onto the trailer, then that is essentially a waiver of a defense, that it would say that it means that the shipper is acknowledging that the equipment is sufficient.
Okay, we're running out of time. Maybe we could just skip to the lumper question, please.
So how do lumpers factor in? Another very good question. As anyone here who's ever dealt with lumpers, from my days working in warehousing and dealing with lumpers myself, I know that we're not dealing with folks who are probably going to be on the cutting edge of the new FDA regulations, and they're probably not putting in plans for FSMA compliance. Fact of the matter remains, though, is that a lumper very well could constitute somebody who's receiving the product, a receiver. So what I would say, if you're somebody who is engaging lumpers here, is that the best practice here, even though this isn't something that's really defined, best practice is that whoever is the one that's actually paying the lumper money to do the lumping services should be taking on the attendant FSMA responsibilities associated with that as well, to the extent that it's possible. So what I would say is engage your lumpers and let them know, look, you've got to meet this. Maybe if you want to provide a certain set of forms, maybe a checklist that they have to complete, it can be accomplished that way. But I would say that if you are the person that is hiring the lumper, you're the one that's paying for it, you should be incurring that responsibility as well.
So let me just drill into this a minute, because paying the lumper is if I have a rate where I have a lumper allowance versus whether I'm paying the lumper versus whether I'm paying a lumper service, and then sort of cross-tab that with, in most cases, the lumper service has been predetermined by the receiver. I don't have a choice on the lumper. I don't have a choice on what I'm paying them. So what then?
I would say then, if you're dealing with a situation where you don't have any sort of access to the lumper, it's the contract loads going to this warehouse, and the warehouse has its own service that's there, or service that's on hand doing it. You don't have any say in who they are, which, yeah, that is extremely common, like you said. Then I would put that on the receiving end, on whichever entity is receiving that. I would contractually push it to them, because you don't have any realistic way of overseeing those folks.
Okay. Well, it looks to me like we basically have about a minute to wrap up here before we get the hook. Chris and Stephanie, any last words for our intermodal audience?
Well, I would say the biggest way to avoid any kind of unnecessary liability when the fingers start getting pointed, when the feathers hit the fan, is to take a look at the contracts that you're using. The one thing you don't want to do here is just keep using the same language and not scrutinize what's coming in. Take a look at what you're agreeing to as it comes in. Really question what you're agreeing to. I know that's common sense, but it takes effort, and we all know it, but it is worth it to do it, so you don't find yourself on the losing end of a freight claim.
Okay. I want to thank everyone for participating and all the people who dialed in to listen.
Thanks so much, Ted and Stephanie and Chris. We really appreciate it. Thanks, everybody. For more information about Intermodal or IANA, please visit intermodal.org or email us at info@intermodal.org.